City and earned both her undergraduate and law degrees from the University of Kansas. Katie has practiced law for more than 20 years. She previously served as president of the Johnson County Bar Association and represented Johnson County on the Kansas Bar Association Board of Governors. She's currently serving her second term on the Kansas Supreme Court Nominating Commission. So welcome to our presenters. You can clap now.
So some clapping's allowed.
And here we go. Thank you.
So we had a couple slide presentations that we were debating whether to show today. This one is a little longer, but we'll be skipping through some of it, but we will make it available to you afterwards if you want to peruse it at your leisure. But I also need to start with a disclaimer. The intent of this presentation is to provide information and education. Any opinions expressed are mine and mine alone and are not representative of the court or the Court of Appeals. I just want you to know that that's my disclaimer there. You want me to? Okay.
And I would say the same. I am the previous president of the Johnson County Bar Association and chair of the Civics Outreach Committee. Judge Arnold Burger and I were doing some of these similar speeches about our merit selection process 10 years ago. So we've been doing this for a while, but to the extent that any personal opinions are expressed, they are mine as an individual.
So here's the amendment, if you want to kind of tell them exactly what the amendment.
Yes, so this is SCR 1611. The language is, the goal is to amend the Kansas Constitution to provide for the direct election of Kansas Supreme Court justices, abolish the Supreme Court Nominating Commission, and permit justices to make contributions to and hold office in a political party or organization and take part in political campaigns. So that is the language on the ballot. A yes vote would require the election of Supreme Court justices. So when you see the signs that say vote yes, that means justices would be elected. Vote no means keeping the current merit selection process in place.
So how did we get here? I always like to start out with giving you some background of how we select judges, how we got to this point, what our founding fathers thought about judicial selection. And to start out, this is the 250th anniversary of the Declaration of Independence. And in the Declaration of Independence, the founding fathers listed several grievances. I can't remember the total number, maybe 11, something like that. But this was one of their main grievances. He, King George III, has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. So if the judge ruled in a way that the king was not happy with, he fired them or he reduced their salaries. So we were upset about that. We didn't want that to happen. So the founding fathers set up 3 branches of government, and the terrifying thing is a study from the Annenberg Foundation survey found that only about 30% of people in this country can actually name the 3 branches of government. That's kind of scary, isn't it?
I don't think that's true for the people in this room.
Oh, no.
I'm very confident that we could
They
all
come to
name
the library.
Yes.
So the 3 branches are the legislative branch, of course, which makes the law, the executive branch, which enforces the law, and the judicial branch, which interprets the law. So the whole thing was set up that elected officials make decisions based on the needs of their constituents, their own beliefs, and their political party's agenda. So we elect members of the legislative branch and the executive branch. Judges, on the other hand, their decisions are to be made on the facts of the case, the law of the case, with a fair and impartial analysis free from the influence of politics. That was the whole idea. We don't want them to have their office dependent upon the decisions they make. And of course, in our system, we have lots of checks and balances. You all heard about that in civics class too. So for example, the president, the executive branch, appoints a judge. The Senate or the legislative branch confirms that particular pick. So it goes back and forth. If the Supreme Court makes a decision that the legislature does not agree with, and if they find that a particular statute is unconstitutional, then they're free to go change the statute to something that may pass constitutional muster. So there are checks and balances on the power of each and every branch. And Alexander Hamilton has his own musical, so we have to pay attention to him. And he says that limitations on legislative authority can be preserved in practice no other way than through the courts, whose duty it must be to declare all acts contrary to the tenor of the Constitution void. Without this, these rights and privileges would mean nothing. And what does he mean by that? And let me give you an example. The First Amendment, one of the provisions in the First Amendment says Congress shall make no law respecting the right of the people peaceably to assemble and to petition the government for a redress of their grievances. And keep in mind, the United States Constitution doesn't give us rights. It protects our inherent rights. So what this says is, doesn't say you have a right to peaceably assemble. It says Congress shall not adopt any law respecting the right of the people peaceably to assemble and petition for grievances. The understanding is you have that right already, and we're not going to let Congress adopt any law to affect that right. So what if you have a legislature that is upset about protests that are going on? And so they decide that they want to ban political protests after 5 o'clock on any day of the week, because they figure most people work, and if they can say you can't protest after 5 o'clock, then that will limit the amount of protests that take place. And so that would go to the Supreme Court to make a decision. Is that a lawful exercise of congressional power or not? Or does that violate the people's right to peaceably assemble and protest? Another example would be the Fourth Amendment. You have the right to be secure in your person, house, and papers against unreasonable searches. They have to be based on probable cause, supported by oath or affirmation, and describe the place to be searched. So they can't just come into your house and search for any reason. They have to have proof. So what if you're home relaxing with your family and the police barge into your house with guns drawn because the neighbor you don't get along with has called them to tell them that you are hiding Nancy Guthrie in your basement? Okay, well, that would be an unconstitutional exercise of the executive power or the police power, and it would be up to the court to decide whether that was a lawful act or not. So what did Hamilton mean? What he meant is that the legislative or executive branches can control the judiciary, then they can pass their agenda unfettered by constitutional mandates. If courts didn't exist to fairly, impartially, and without political pressure declare these statutes unconstitutional or this search unreasonable, the legislature could pass any law it wanted. The executive branch, through its police, could enforce it however it wanted. Any provision in the Constitution preventing their actions would be meaningless in practice. So again, Alexander Hamilton, there's no liberty if the power of judging not be separated from the legislative and executive powers. This is a different branch. They are not to be governed by politics. Liberty can have nothing to fear from the judiciary, but it would have everything to fear from its union with either of the other departments. And the judiciary is in continual jeopardy of being overpowered, awed, or influenced by the other two branches. So how did they decide they were going to select judges then? They didn't like the way the king did it, so what did they come up with? Well, we have Alexander Hamilton, again, at the heart of this debate. And so they decided first, okay, the president can appoint, just like the king, the president can appoint the judge, but we're going to have a couple checks on that. One, we're going to have Senate confirmation. Now, why do we have that? We have that, according to Hamilton, so that a president can't just appoint an old crony who's unqualified for the job to be a judge. Now, you may disagree with the United States Supreme Court and what they've done in some of their decisions, but I don't think any of you could say that the justices that have been selected weren't qualified for the position they were selected for. But an example of this in action was back during George W. Bush, when he tried to, if you recall, tried to appoint Harriet Miers to the Supreme Court. She was his chief counsel. She had no constitutional law experience. She really was totally unqualified for the job. And our own Senator Brownback fought valiantly so that she would not be confirmed, and he eventually withdrew her nomination. So that's kind of an example of what that was put in. And remember, back then, senators were not elected individually. Each state decided which two people were going to go to the Senate. It was kind of like the House of Lords. These were the elite of the elite, and these people would decide if the president was overstepping his bounds. Second, and this is key, was lifetime appointment. Why do you think federal judges are appointed for life? They're appointed for life so that the winds of political change and pressure won't affect their decisions. They can make their decisions free of that. And third, there was a protection against reducing their salaries. So you could not reduce the salary of a judge to try to get them to do what you want, because as Alexander Hamilton also said, the general course of human nature, a power over a man's subsistence amounts to a power over his will. So if you have a power to decide whether somebody is going to have that job or not, then that's going to definitely affect their will. So that's how it was. Nowhere in the country or in the world were judges elected. That was just not part of the discussion. And then you have the Jacksonian democracy period. When Andrew Jackson came into power, there were multiple political parties. He wanted, for example, an interesting thing under Jackson was at that time, anybody that owned any white property owner could vote. You didn't have to be a citizen. You just had to be a white property owner. So Jackson, one of his big changes from this elitist system was so that all white males could vote. You didn't just have to own property. Citizenship was not a requirement anywhere until 1868. But he also believed in, because there were so many different political parties, that once you got into office, you better grab it and do what you needed to do, because it may not be guaranteed for too long. So he started this patronage and spoils system, and it was encouraged and valued, and he is the one that coined the phrase, "To the victor go the spoils." Okay? So populism rises, there's a strong executive branch, and we started to have election of judges. Okay? That's when some states started electing their judges. And so when Kansas came into the Union in 1861, we elected our judges. But the dominoes started to fall. 1832, Mississippi, 46, New York, 51, Ohio, 51, Indiana. Up until this point, they were not elected. They were appointed much like the federal system. And then each new state, as they entered the Union, entered with an elected Supreme Court. That's how we got elected judges in Kansas in 1861. Then you have the progressive era that comes into effect with Teddy Roosevelt, who believed in merit selection and efficiency, and civil service was all taking place under Teddy Roosevelt. He established the first secret ballots. Up until then, your ballot was not secret. He established referendums so that the people could change the actions of the legislature and adopt laws, and recall fights in order to fight the overwhelming power of political machines that were having an impact everywhere, including in judicial elections around the country. And at that point, we went to popular election of senators, the 17th Amendment. All right, so then we had the Missouri Plan was born. Maybe you'd like to talk about that.
Sure, I will. So at this time, the historical context is that Kansas was electing all judges, and we get to the Missouri Plan started sweeping the country, particularly in the Midwest. Missouri, and we still call it the Missouri Plan to this day, but it established a permanent nonpartisan commission. It was made up of lawyers and non-lawyers, and the goal was to do the search for the most qualified applicants, really digging into the scholarship, the temperament, the character of the applicants, and then sending a list of the most qualified applicants, 3 to 5, to the governor, who would select from that list.
And it was born out of Tom Pendergast. That's why the Missouri Plan came to be. Tom Pendergast was paying judges, police, everybody were on his payroll. So the people of Missouri got sick of that corruption and developed this plan.
So states utilize one of 3 judicial selection models. So there is the election model, and those can be either partisan or nonpartisan. There are appointments, which are similar to the federal model. Different states do it differently, but generally it is the federal model where there is some form of legislative input or confirmation. And then there's merit selection with the retention component, using a nominating commission to review the candidates, followed by appointment, and then retention elections where voters get to have a say on whether it was the right choice or whether the judge or justice is doing a good job. Since the Missouri Plan was first used in 1940, no state that has had merit selection has switched from merit selection to the election of justices. Kansas would be the first under the proposed amendment. It has not been done before. So this map shows you color-coded, and my glasses are not gonna help me read those colors, but you can see the purple that we like, the Missouri Plan, the merit selection, particularly in the Midwest. And then the greens show either a partisan or nonpartisan election. The gubernatorial appointment is shown in brown, and then there are a couple of different hybrid models with very few doing legislative appointment alone. So how did we get from electing judges and justices to our current system of merit selection, and why? I bet among this group people have heard of the triple play. I'm sure of it, because we all know what 3 branches of government we have. Judge, you want to do this, or do you want me to talk about the triple play?
Why don't you go ahead?
Okay. So as we said, all judges are elected at this point. There was the Pendergast political machine in Missouri, and of course Kansas had its own version of political corruption. And now not being able to read is real. I might need your help. So let me see how I can do. This is my test. So we had a Republican governor, Fred Hall, who at that time we had 2-year terms, and Governor Hall had embarrassingly lost his own primary and was a lame duck governor. His good friend, William Smith, was the Chief Justice of the Kansas Supreme Court at the time. So as we near the end of the year, Governor Hall starts to worry about his paycheck, about his benefits. He's wildly unpopular among his own party, among the other parties. And so he's really worried about job security at this point, doesn't know what he's gonna do next. So he devises this plan. So he's a lame duck governor. Chief Justice Smith in the hospital resigns his position as Chief Justice. Coincidentally, Governor Hall then resigns as the lame duck governor. His lieutenant governor, John McNish, then becomes the governor for something like 11 days or a week and a half.
And he's in the hospital too.
Everybody's
They have to go
sick.
get him out of the hospital to do this.
But these guys have a plan. So in his 11 days as governor, he appoints his good friend and recently unemployed Governor Hall to become, anybody? Chief Justice of the Kansas Supreme Court. This did not go over well. It didn't go over well with Kansans. It didn't go over well
You can keep pushing, I just have little arrows.
Oh, okay, I see. God, you're so good at that. Look at those little arrows. That's a triple play right there. People did not like it. They called it a brazen raw deal for Kansas justice. That was William Allen White. It was an offense against the whole idea of an independent judiciary. That was the Iola Register. The Democratic state chair said, I thought I was a pretty good title attorney, but this is the greatest shift of titles I've ever seen in such a short time, this sucker shift. The thing Notre Dame used in football, which goes over my head completely, but sounds like it's bad for the other team.
And so the movement starts to change to the Missouri Plan. And what I wanted to show you here is I have some clips from the newspaper back in the time. You know, there are some things that have come out that said, Kansas should reclaim the election of judges, suggesting that perhaps our ancestors, our grandparents, our great-grandparents were duped somehow into changing to the Missouri Plan. And every now and then you'll see things that were in the paper. They discussed all of the same things we're discussing now in 1957. They discussed how many lawyers are on the commission versus non-lawyers. They discussed how this was going to work, and it was hotly debated. So I put these up just to show you this isn't new. This is not a situation where in 1957 they were duped to go into a system that was wrong. They fully evaluated all the things that needed to be examined. The state chamber, today we have the Kansas Chamber of Commerce, who's for the election of judges. Back then, the Chamber of Commerce was for the merit selection plan. They wanted that plan in place. They also talked about the fact that Hall had no judicial experience. He practiced law for about 6 years. His best friend would admit that he comes about as far from having a judicial temperament as anyone can imagine. He's combative and opinionated. His whole being is steeped in politics, personalities, and prejudices. The idea being, if you have a person who's elected to the position, there's been no vetting of what kind of judge they would be or what their scholarly abilities are. So merit selection was adopted by a constitutional amendment in 1958, 60 to 40%. So that's how we get the current system. And you are just intimately involved with the current selection process, so I'm gonna have you go from there.
Right, so I've been getting flyers, and I've had friends texting me when they get flyers or they see ads and say, what's this all about? And the one that makes me laugh the most is that our current method of selecting Supreme Court justices involves lawyers in smoke-filled back rooms. And I just think, first of all, I did not get invited to the smoky back room party.
She's on the commission.
Obviously, there's no smoking allowed in the state, judicial center. But I have had the pleasure and the honor of serving I'm in my second term on the Kansas Supreme Court Nominating Commission. So the method of selecting justices that Kansans chose overwhelmingly in 1958 remains in place today. And under that system, the Supreme Court Nominating Commission was formed by that constitutional amendment, so it is part of our state constitution. The members of the Nominating Commission are 4 laypersons selected by the governor, 1 from each of the 4 congressional districts.
And we generally call non-lawyers laypersons. I don't know if that's a good term or not, but that's
instead of saying non-lawyers.
Instead of just saying non-lawyers.
As though lawyers are the standard, definitely. And I had added at one point a little slide, I don't know if it made it into this one, but if you picture the state of Kansas in the map, and you can see the congressional districts and how they're carved out. Each congressional district has a lawyer member and a non-lawyer member. The lawyer member is elected by lawyers in that congressional district. So when I ran, and I have no idea what made me think I was, ready to do it. I had no idea 4 other people were gonna run for the same position. So it is an election. It is the entire congressional district. So it is dependent on you as a lawyer having a reputation for integrity, honesty, and appreciating and understanding the importance of a fair, impartial, and qualified judiciary. So that being the system, we had an election, I won, and then I ran for re-election. It was also contested, so I had to be elected a second time. And that is true for each of the lawyer positions. The non-lawyer positions are appointed by the governor in office, and they're staggered terms of 4 years. So when I first joined the commission, there were members who had been appointed by a Republican governor. There were members who had been appointed by a Democratic governor. So there are 9 total members.
Do lawyers vary as well? Are they all Republican or all Democrat?
They're either no one knows, or they're one or the other. It is not a partisan election at all. I didn't tell anyone when I was running, what my affiliation was at the time. The 9th member is a lawyer elected by lawyers statewide. So all of the lawyers in the state get a ballot to choose the chair, and the chair, runs the meetings and speaks for the commission. The process is incredibly intense. So any applicant, a Supreme Court justice applicant has to be 30 years old, has to have been practicing law for 10 years. The application is very lengthy. We delve into their academic record, their scholarship while they were in law school. Were they on the law review? What was their GPA? Did they have any disciplinary issues in law school? And then we look at every single example of their employment. We talk to people they worked with. It doesn't matter if it was 20 years ago, if it was 25 years ago. And each member of the commission, each lawyer and non-lawyer is assigned, depending on the number of applicants, 1 or 2 applicants to investigate. And we are digging. We're not just talking to the references listed. The people I always want to talk to is I want to talk to legal secretaries, paralegals, court reporters, administrative staff. I want to talk to subordinates. I want to see how does this person treat people that they don't have to treat well. I want to know what their reputation is with opposing counsel. So the applicants that I've interviewed recently, I'm talking to opposing counsel from 10 years ago, 15 years ago. How did they conduct themselves in litigation? When things are stressful and there's a deadline, how are they treating opposing counsel? How are they treating their staff? Are they behaving in a way that shows a judicial temperament across their career, not just when they're applying for the Supreme Court? And so all members of the commission, I can assure you, I've seen it personally, take it incredibly seriously. We are looking under rocks. We're not looking to confirm all of the accolades or awards that the applicants received. We're looking for anything that indicates this is not the most qualified candidate. And again, we're looking for intellectual ability. We review writing samples. If they're sitting judges, we can look at what their rate of being overturned on appeal is. We're looking at the kinds of cases they handled. You know, someone could have a really good, for example, divorce practice, right? It's not the kind of legal experience that we're typically looking for the Supreme Court. We are looking for justices who have handled complicated legal issues, procedural issues, complicated litigation over a career, usually decades-long career. And that's what we mean by merit. So if anyone, I've had that question, what does merit mean? Well, let me tell you, it'll take me 20 minutes, but that's what the answer is. So once we go through that process, we come up with the 3 most qualified candidates. We might have anywhere from 14 to 25 applicants, and we vote, and it takes rounds of voting frequently. All of this is public. If anyone's super bored tonight, you can go home and go on the Kansas Judicial Center YouTube. I think this is later in the slideshow. You can watch our interviews of the applicants. You can hear their answers. You can watch us vote. And our meetings are subject to the Kansas Open Records Act and the Kansas Open Meetings Act. And so there's always a request for our ballots as soon as they're turned in, and you can see how we voted.
It's usually in the paper.
It's usually in the paper, yes it is. All right, so we'll come back to that.
So now we'll
process.
start talking about some of the details of what's happening now. So first, the amendment is put on the primary. So the first question is why? Why is it on the primary ballot? Primary elections generally have lower, more partisan turnout, proportionally more Republican voters, reduces participation by independents because they're not used to voting in primaries. And so why was the primary selected? And all of these slides, I'm just going to give you what the published reasons each side has stated for each of these things, okay? So why the primary? And this just shows you in the 2024 presidential election, 7% of Kansans eligible to vote voted in the primary versus 59% in the general. So there's stark differences. Okay. So the proponents, the vote yes people, this is a valid discretionary legislative choice that allows any change to take place sooner. There's this urgency about it, that we need to have this go into place 3 months earlier. It gives a standalone focus and it prevents it from competing with the other constitutional amendment that's on in November on voting. Time Masterson, we're putting it on a regularly scheduled election when people are already voting. Chris Kobach, this is something Kansas have wanted for a long time. They should have a chance to vote on it. Of course, they did vote on it in 1958. That was me personally saying that. Opponents, they think voters should have a bigger role in the selection process. I find it ironic that they've chosen to place this constitutional amendment on a ballot of a low turnout election. Okay, so those are the 2 positions. So here are the publicly stated pros and cons. We can trade off on these maybe.
Sure, so proponents say you should vote yes because 5 of the 9 members of the nominating commission are lawyers. It is an elitist system where Kansas Bar Association controls who advances to the court. Less than 1% of Kansans are attorneys and they control an entire branch of government. Senate President Ty Masterson has said, should lawyers chosen by other lawyers decide, or should that power belong to all people?
Do you all hate lawyers? We don't feel a lot of love from those
No.
statements.
But I do know that when a mom friend from my kid's school or a neighbor needs to know how a judge is doing, if their sister is getting a divorce or their cousin has a bad construction case, they want to ask a lawyer, who is this judge? Are they good? Are they fair? What do you know about this judge? So we as lawyers know that we are the first ones that people come to ask about the qualifications of a judge when it's our friends and family that have those cases.
I generally don't ask my plumber who I should go to for a cardiologist, and I'll just leave it at that. Okay, so this Manhattan Mercury, September 28th, they assert that attorneys representing a few influential interests not responsible to the public can control the choice of judges. That was a complaint. Back then, you got too many lawyers on here. But they went ahead and adopted it the way they did, and there is absolutely no indication that the lawyers vote as a block.
No, on the contrary, we have multiple rounds of voting until we get to the top three.
Okay, opponents vote no because lawyers on the commission represent a cross-section of the state. They include Republicans and Democrats. There's no indication of block voting. And this is key here. We know this is not the reason to a push for election of judges, the majority lawyers on the commission. We know that's not the reason, because all they would do to make that happen, need to do, is a constitutional amendment to change the makeup of the nominating commission. They can change the makeup of the nominating commission so that it doesn't have a lawyer chair. They can make it so it doesn't have any lawyers on it if they want. But that suggestion was specifically rejected.
Proponents also say, vote yes because the current system provides no accountability. Judges should be responsive to public concerns, which I think Judge Arnold Burger is going to talk about. The people should be able to remove a judge if the judge's decision is contrary to the will of the people. Elections will better align the courts with public values.
And here are some examples of what they've said.
So, we have had Senate President Ty Masterson on record saying, you know, you get to decide who your governor is, you get to decide who are in the legislature, but nobody gets to decide other than those few who really get to make it to the high court.
And that's kind of a sexy argument. I mean, that's what people will usually turn to. Well, I vote for the legislature and I vote for the governor, why shouldn't I vote for judges? Voting in a democracy is an effective means of expressing individual political preference. They talked about this in 1958.
Back in 2015, Governor Brown back at that time made it very clear that they needed to.
Because they were trying to make this change back then. The constitutional amendment has never made it through the legislature to get out on the ballot, but they started trying in 2015.
There was years of litigation over school finance, and the Supreme Court had issued some decisions about how the legislature needed to fund public schools in Kansas. And Governor Brownback at the time said, go along with us on this judicial selection issue and let us change the way we select judges so we can get judges who will vote the way we want them to.
Yeah, let's elect a dishonest judge.
Although, and he also said, activist courts should not overrule the people of this state. No single judge should be allowed to change the will of the people with the stroke of a pen. I hazard to guess that Brown versus the Board of Education would have never happened.
Well, you don't
we
have
were
to
going
hazard
with
to guess.
public.
I think the polling that back then would show we would not have had that same result if it were left up to the will of the people. And this goes back to the founding fathers and what we were talking about at the beginning. When we're talking about a politician that's trying to get our vote and they want our donations, they're saying, here's how I'm going to vote. Here's what's important to me. Here are my values. Here's my platform. Here's my political party. And as voters, we can say, okay, that aligns with what's important to me. I'm going to vote for you. And that kind of dialogue is expected for elected officials. But as we talked about at the beginning and we'll talk about again, the purpose of the court system is to make decisions based on the Constitution and the law. And applying the Constitution and the law to the facts of the case is completely distinguished from following a platform or following your personally held beliefs.
So we need to have courts that are not activists in striking things down. So basically, if the legislature passes a law and the court finds that to be unconstitutional, then that's an activist court who's striking things we've adopted down. And remember, we talked about that. The whole point is Alexander Hamilton was You know, if you don't have an independent review of legislation, then your constitutional rights mean nothing.
Going back to Nancy Guthrie not hiding in your basement, that's
Right.
why we need a court system to say that's an unreasonable search and seizure.
Right.
So then, if you get a nominee who takes the bench, we don't have any way to deal with the bad decisions that may come out of that decision process. This was Senator Mike Thompson during the March debate on the Senate floor.
The question is, who makes it, who decides it's a bad decision?
Correct.
I'm sure somebody likes the decision.
Everybody thinks it is, there's always gonna be 50% that think it's a bad decision.
The change Kobach said would clear a path for the state to slowly and quietly place anti-abortion judges on the state's high court, with the ultimate goal of overturning the Kansas Supreme Court's 2019 Hodes decision that found the state constitution includes the right to abortion. Stated reason to elect judges. After discussing his dissatisfaction with the abortion decision, Ty Masterson, we are in a lot of trouble in Kansas unless we can change our Supreme Court and get an opinion that goes the other way. But you can't go out there and say it, because they'll say if you elect your Supreme Court, you won't have any right to abortion anymore. But we elect Supreme Court, they won't force you to spend more money on schools. Opponents.
Opponents say vote no because our founders set up the judicial branch to be a check on the other two elected branches. So the changing winds of public opinion and political special interest would not usurp the rule of law. One of the listed complaints in the Declaration was that judges were made dependent on the king's will alone for the tenure of their offices and the amount and payment of their salaries. So we've come full circle. Opponents say vote no because justices are held accountable by rules of ethics and mandatory retention votes. So after the Supreme Court Nominating Commission does their job, sends 3 names up, the governor, whoever the governor is at the time, selects the most qualified candidate, and there's another layer at that point. There are interviews, there are KPI background checks. You've got multiple layers of investigation, review of the judges or the lawyers' disciplinary record. Anyway, there are multiple layers. Once the governor selects the justice, that justice is going to be up for retention, and that means they are going to show up on your ballot. They show up the first general election after they're appointed, and then every 6 years. So under our current system, Kansas voters do have the opportunity to tell the commission or the governor that we got it wrong, or to say that a justice in issuing their decisions has lacked the qualifications or the temperament or the right to hold that position. So under the current system, it is merit with retention votes by Kansas voters.
That just shows you what your ballot generally looks like when there's a judge on it. And how can you find out about these judges? That's the next question people ask. Well, they're up for retention. I don't know anything about these judges. Well, there are lots of ways. One is their arguments are live streamed and archived. Again, if you're bored tonight, go online to the judicial branch. You can watch every argument before the United States Supreme Court or the Kansas Supreme Court. You can see how the justices react, what kind of questions they ask. Every Friday, all their decisions are posted. You can go read their decisions if you want to see how they're deciding cases. The Kansas Bar Association, and I put myself up there. I wanted you to see that I got 92%. The Kansas Bar Association began for appellate judges in 2024. Let me go back. Remember back in 2015 when there was a move to move this to election of judges, we had a Judicial Performance Evaluation Commission that sent out surveys funded by the state that sent out surveys to not just lawyers about judges, but staff, jurors, everything. And they came out and published information about all the judges on the ballot. Well, the first thing that was done was they defunded that. Because how can you say that our judges aren't qualified if you have this system that shows they are qualified? So they disbanded that. So there was some scrambling to try to get something in its place. The Kansas Sunflower Coalition, which was a group of newspapers, started doing those evaluations, but they're expensive. And so finally in 2024, because there felt to be some need for people to know about these judges, the Kansas Bar Association started doing surveys and sending them out. They've sent out the surveys for this upcoming election, and those will be out and published in August. So, and this is just the summary on the front. It goes into detail about, You know, does she know the law? Is she have a good demeanor? Is she fair? There are all kinds of different criteria. Ask a lawyer. You know, if you want to know about a judge on the ballot, ask a lawyer. Most of them will give you an opinion as to whether they think.
A lawyer will always give you their opinion on Proponents say vote yes because Kansans should reclaim the right to vote for judges, which was taken away in 1958. I mean, I think we've talked about that. This was hotly debated. It was the result of the reaction of the triple play and the political machine that Kansas actually said no to.
Vote yes because Kansas is an outlier. Most Supreme Courts elect their justices. We know that's not true. 22 out of 50 states do provide for the direct election of Supreme Court justices. 8 are partisan, 14 are nonpartisan. But again, as we said, no state that has gone to merit has returned to election. That would be the outlier. This shows you in the Midwest, we like our merit selection.
I saw this too, and there's been a lot of discussion about it. The proponents are saying vote yes because Kansas has the most overturned Supreme Court in the nation, citing data that purportedly shows 87% of Kansas Supreme Court decisions since 2007 that were heard by the U.S. Supreme Court were overturned. And this is Senator Mike Thompson saying that fact alone should be disturbing and concerning.
But this is really misleading because one, you have to look at how many cases, you know, if somebody loses in front of the Kansas Supreme Court, they can ask the United States Supreme Court to hear it. So from 2019 to 2025, only 73 cases went up to the Supreme Court to decide if the Supreme Court was even going to review them or not. So what this is cherry picking a very few number of cases accepted. But since 1966, when a majority of the Kansas Supreme Court were appointed by the merit selection system, the national reversal rate for the states is 77%, Kansas reversal rate is 66%. Now that sounds like the United States Supreme Court is reversing a lot of decisions by these states, but what you have to keep in mind is they're taking just a very small number, and as we say on the Court of Appeals, because the Kansas Supreme Court can decide whether to look at our decisions, they generally don't take the case to give us an attaboy. They've usually decided to take the case because they think there may be some flaw in it. So this idea is kind of a cherry picking of data, I think.
I think it's generous. I think it's very misleading. Proponents say vote yes because decisions are secretive, there is no transparency. This is a quote from Chris Kobach. People, not only lawyers in smoke-filled back rooms, there it is! Where is the smoke-filled back room? Should know the reason selecting Kansas Supreme Court justices.
Vote no because open, transparent, extensive review of all applicants. This is the nominating commission before one of their meetings discussing about, there's Katie with long hair down there, yeah. So you can watch it live. You can watch the questions they're asking. You can watch how they decide who they're going to interview, how they're going to divide up the caseload. This is not this time, but the last time, this is a link to the interview process. That happens to be just coincidentally Chris J. Ram interviewing, who's the one that was just appointed to the Kansas Supreme Court by the governor.
Opponents say vote no because anyone can apply to be a judge regardless of their party affiliation or income, or regardless of their ability to raise money, okay? You can be the smartest person in the room, the most qualified person, but if you don't have the connections, if you weren't born into the right family or part of the right political machine, you're not going to be able to raise money. I know that's not on there, I just added it. They are evaluated by their qualifications, their reputation, their scholarly and academic work, the extent of their legal and trial experience, their integrity, their reputation for fairness and demeanor. None of that, notice how none of that has to do with how much money they can raise. Yeah, sorry, I could go on.
Yeah.
Opponents say vote no because do you want a constitutional scholar or a movie actor, an impartial jurist, or one who campaigns well? If I had to campaign for office, nobody like me would be elected. I was a nobody.
And he was. Lee Johnson was a brilliant attorney from Caldwell, Kansas.
Not far from Ark City.
Not far from Ark. You know, they asked me before we started, is it Arkansas City
It's
or Ark?
Arkansas City.
And I said, well, you know, we're in Kansas now. You know, he was a small town lawyer. that rose to the top because his qualifications were stellar, his scholarly work was amazing, and look, they even talked about this in 1958. Some highly qualified men, because they didn't think women could do it then, will not seek justiceships because they do not wish to become openly involved in partisan politics. This is the chief argument of those who are dissatisfied with the direct election of Supreme Court justices. You're not going to have the same quality of people. Here you go.
Proponents say vote yes because the current process is political. It is just secretive, behind closed doors, done in private, away from observers. Well, as we've talked about, this isn't just misleading, it's patently untrue. The interviews themselves are actually open to the public. If anyone wants to drive to Topeka, you can go sit there, or you can just watch it online.
So who's being secretive here is the question. The amendment only says the nominating commission will be abolished and justices will be elected for 6-year terms, and they can contribute to political campaigns and hold political office. The actual rules of the election will be decided by the legislature later, and they could change yearly. Are these elections going to be partisan or nonpartisan? We don't know. Will it be statewide or regional? We don't know. What are the filing rules, the timing, the campaign rules, the ballot format? We don't know. The rules are subject to change with each legislative session. But the vote yes people say,
Oh, it'll all work out. Well, just trust us. We'll tell you later.
seriously, that's been the response. Vote no because if other states are any indication, election of judges means that big money will come into Kansas to push partisan politics, required to win millions. It is the equivalent of hanging a for sale sign on the state's Supreme Court house.
Opponents say vote no because justices are and should continue to be prohibited by the Kansas Constitution from making political contributions or participating in political campaigns or holding office in any political party or organization, to guard them from political influences. If not, they will become beholden to special interest groups who will contribute to their campaigns, expecting support for their causes.
And how much
How much
money,
money?
Katie?
Wisconsin, 2025, $51 million per judge candidate. So I saw another figure a couple days ago that showed the 2023 Wisconsin Supreme Court. I think it was something like maybe 25 million total or 50 million total.
Yeah, it's
Within 2
skyrocketing.
years, it had doubled.
And the major contributor in the Wisconsin campaign was Elon Musk.
Right, it's not, if we look around at our fellow Kansans, and we're saying that each Supreme Court justice seat is going to be $10 to $50 million per seat, that money isn't gonna come from Kansans. Yes, you're gonna be asked to donate constantly, and you're gonna see ads, and they're gonna be AI ads, and it's all gonna be absurd, but that money isn't gonna come from Kansans. It is gonna come largely from outside the state, on both sides, on all sides. This is not a red or blue issue. It is gonna come from special interest groups across the board outside the state.
In a nationwide 2001 poll of approximately 2,500 judges, only 36% believed that campaign contributions have no influence on their decisions. Nearly 9 in 10 voters believe that judicial campaign support, whether in the form of direct contributions or independent spending, influences judicial decisions. And there's a recent book, Free to Judge, The Power of Campaign Money, that shows that that's true. It works. The amount of money spent on campaigns has a direct correlation to the amount of the number of justices that vote pro-business. I put up there in the corner of the book, The Appeal by John Grisham. I recommend you read it. It's fiction, but it's based on what really happened in West Virginia when the coal companies bought a Supreme Court justice to get an opinion switch.
There was a California Supreme Court justice, I think this week, was a California. He said, being a justice and knowing that you have a campaign around the corner, trying not to think about money and donations, is kind of like walking into the bathroom to shave and there's an alligator in your tub. You're gonna shave, but you're gonna be thinking about the alligator. It's really hard not to think about. And so the idea of having campaigns and re-election and fundraising on your mind all the time as you're issuing decisions is really hard to fathom.
As Anton Scalia, former Justice of the United States Supreme Court, said, one cannot have judicial elections without judicial campaigns without funds for campaigning, and funds without asking for them. And lo and behold, in 1958, this was an issue too. And one of the things they said was even more dangerous to the citizenry is the precarious situation in which a lawyer and his client might find themselves when face to face with a judge whom they had bitterly differed on a party issue or a feud within a political party. Do you want to be in front of the judge that your lawyer did not contribute to, but in fact contributed to their, okay, vote yes because.
Vote yes, proponents say vote yes because despite the costs, elections increase accountability. The process is already political, but it is hidden. Elections will make the politics more transparent. We want judges that will vote the way we want, and if the political process with the opportunity for special interest campaign contributions that align with our agenda makes that happen, then people have prevailed. Proponents say vote yes because you can't say the U.S. Supreme Court isn't political. It is clear justices have been placed on the court throughout history, and that the appointing president believes will pursue the president's partisan agenda and uphold the president's actions.
So they're saying even a selection system is political. But what I'd like to propose to you is the Kansas merit selection system protects against those abuses inherent in the federal system. Because one, anyone can apply. Not just one selected by a group of political supporters. Anybody who wants to apply can apply. The list of applicants is made public. How do you know who the president is considered for a particular position? The qualifications are vetted publicly and reviewed extensively by a nonpartisan commission. The commission accepts and considers public comment. The governor must choose from among the 3 qualified applicants. In other words, it's set up so the governor can't go wrong. That's the idea. Any of these 3 would be good. Governor, you pick whatever you want. If of those 3, one is a Republican and the other 2 are Democrats and you're a Republican governor and you want to decide to pick the Republican, fine. But you're not going to go wrong merit-wise with any of those 3. There is opportunity for the voters to decide whether to retain them every 6 years. And the key there is there's no lifetime appointment. There's an age limit in Kansas of 75. So we have some protections really that make our system better than the United States Supreme Court system. Oh, I wanted to show you this. Is this okay? All right, so these are the vote no signs that you've been seeing out there for the last 2 or 3 weeks, okay? This week, oh, and this is the vote yes signs, choose democracy, elect our judges. But this is what started happening this week. Tricky, tricky, tricky. Let's confuse people. These are just a list of organizations that are behind vote yes, and the ones that are behind vote no. So I think with that we can.
Would you go back?
To that.
You want to see that?
Yeah, I want to
Yeah.
see the ones you want, yes.
Okay, the yes, Americans for Prosperity, those are the ones that are sending you all the flyers. They have their logo on there. Kansas Chamber United for Business, I think that's the same as the Kansas Chamber. If I have a question mark there, it means there's somebody from the chamber that has said they support the amendment, but I wasn't able to find it on their website. The Kansas Policy Institute, Kansans for Democracy, I'm not sure who they are. They're not required to disclose their donors, but we know that they don't have a website, but we do know they've raised $800,000. Republican legislators that voted to put it on the ballot, a group called Kansas First, the Kansas Republican Party, and the governor, all the governor candidates, Republican governor candidates, have taken a position except Vicki Schmidt. She has not taken a position one way or the other. Vote no, Kansas United for Impartial Courts is probably the biggest one. Women for Kansas, Kansas League of Women Voters has actually taken a position on this. Kansas Association of School Boards, Kansas Appleseed Foundation, American Federation of Teachers, Johnson County Democratic Party, and virtually every Democratic Party out there. American Civil Liberties Union, Stand Up Blue Valley, Protect Kansas Rights, the Kansas Bar Association, Kansas Women Attorneys Association, Planned Parenthood, Kansas Federation of Democratic Women, the AFL-CIO of Kansas. Those are the ones as of June 4th. There are probably more on each list now.
Okay.
Okay, we have time for one question. Just
Not
kidding,
all.
just kidding. We have time for more.
Thank you for you're staying a little longer, but I can see everybody's really interested, so we're gonna, Ashley's gonna give you questions and I'm gonna say them. Okay. How many states now have direct judicial election?
Of their Supreme Court?
Of Supreme Court.
22.
22?
And of those, not all of them are partisan.
Some are partisan, some are nonpartisan.
Okay. How impartial can a nominating committee be if 8 of the 9 made large donations to Democrat candidates? And then there's a source here on that.
I saw that
It's
and
in the
I
paper today, I think.
I didn't think it was accurate because I'm familiar with some of those donations myself personally, and now my husband is, so thanks, guys. The reality is that the 3 names that we just sent up, of the 3 names, there were all 3 district court judges, 1 in Douglas and 2 in Johnson, and 2 of them had been appointed to the bench by a Democratic governor, and 1 had been appointed to the bench by a Republican governor. So we are looking for the most qualified candidates regardless of the party of the governor who appointed them or what we would know about their political background. If you watch the interviews, we're not asking them their feelings about abortion or school funding or data centers or immigration. We're not asking those questions. We are asking, and again, watch the interviews.
So,
Look at
I think what the article said was, look, these members have donated to Democratic causes. You may have donated to Republican causes too, I don't know. I think that's
They
usually
didn't
the
include
case.
those.
Right, they only included which Democratic candidates they had contributed to, but a lot of people, especially attorneys, and Katie, correct me if I'm wrong, attorneys and law firms will donate to both sides. But what was, and I don't know where they got that information, but I think what you're saying is the proof is in the pudding. Look at
Yeah,
who are
absolutely.
nominated.
And look at the names that have gone up for the past, at least I know, the past 8-10 years, and these are some of the most brilliant minds with the best judicial temperaments, regardless of who appointed them to the bench or their background or their political.
And that would
affiliation.
also seem to suggest that somehow members are block voting. And we know that's not the case at all, because it
Zero
takes
ballots.
numerous ballots sometimes to get somebody through.
We're nervously discussing how we might not get to all the questions, because they're all really good, but Ashley's working on it. Can a governor reject all 3 nominees? What are the, and then there's one more question here with this, what are the current costs for a current candidate, and how do the costs get funded?
There are no costs associated with applying to be a Supreme Court Justice in Kansas. And no, the governor cannot reject the 3 that are sent out from the
They have
commission.
to choose one of them.
Correct.
Okay.
Okay, next we have, what judge or justice has lost a retention vote? If none or nearly none of them, then why pretend that a retention vote is meaningful?
I love that question.
That is,
I really do.
Dance around that.
Because one answer to that is, maybe they're retained because the system works. And there are good judges, maybe that's the case. I can tell it, but that's correct. There's never been a case that I'm aware of where Kansas Supreme Court Justice has not been retained in office. There's only been one time I know of where there was a push not to retain them in office, and that was in 2016. And the push was, don't retain any of them except Caleb Stegall. That was the flyers that went out. And they still made it through, but I think with 52 or 53%. So voters were faced with, we don't think you should retain these, we think you should, and the voters retained them. So I don't know why we discount that vote. Well, that must not have meant anything if they continue to be retained. I think even in 2016, I think most of the judges were retained by more votes than any of the candidates even got. So I don't know how we decide which votes we think are okay and which votes don't
Valid,
make any
right.
sense.
Yeah, a voter's vote is their
It's a
vote.
voter's vote.
Yeah.
okay, great. I don't know exactly what this means, so maybe you will. This says, can you steel man your opponent's argument, i.e. describe it as well and as fairly as possible?
I think that's what we tried to do with the proponents say this, opponents say that, so.
You were giving both
We're
sides
giving
of them.
both.
based on the ads that we've seen in the flyers and the newspaper articles, that's certainly my understanding of the major votes on, or the major arguments on both sides.
So that was to see them side by side, okay, great. Isn't it political when the Supreme Court makes new interpretations of existing law that grant rights to some and remove from others? Is that political?
It's, okay, so as a judge, when you're faced with a legislative enactment that legislative enactment may give rights to some and not to others, you are required to examine that as best you can, try to determine legislative intent by the words that are written, and make your best judgment as to what you think that statute means. And the legislature may disagree with you. And if they do, the abortion situation is the perfect example of our system at work. Because the Kansas Supreme Court issued a decision saying, I mean, very simplistically, that you have a right to an abortion in Kansas. Okay, let's just make it simple. And the legislature said, no, that's not what the people want. The people believe you don't have that right. So we are going to put forth, since the Kansas Supreme Court said this is what the Constitution says, we're going to put forth an amendment to change the Constitution to say what we think it's meant all along. Perfect. That's exactly what our system is supposed to be. So they put forward a constitutional amendment saying that you don't have the right to an abortion in Kansas, and the voters rejected it, which is also our rights as voters. So again, I'm not, the question I guess is, courts don't decide legislation based on what most people believe. I mean, they have to look at the legislation that was passed. They have to look at it in context with other legislation. It's a very complicated process, but there's always that check and balance that if the voters think the Supreme Court got it wrong, then you go to your elected representatives who share your viewpoints and get a constitutional amendment on the ballot. So that, the abortion, there couldn't be a better example.
Okay, great. Does that make sense?
It did, thank you. Everyone, your handwriting is fabulous. I just want to tell you, this one was just small, so I needed glasses. Does the amendment impact appellate selection, or is that a different process? And then, will the PowerPoint be available now?
Yeah. And the same PowerPoint is out there already too. What was the first question?
The first question was, does the amendment impact the appellate
Okay,
selection?
no.
Not yet.
Not yet. The Kansas Court of Appeals, they changed our selection method back in 2016 because we are not a constitutional court. We were only established by state law. So all they had to do was change the state law. So they changed the law to make it governor nominates, Senate confirms. So it's just like, we call it the federal system light because you don't get lifetime appointment. But it's the governor selects and this governor has elected to set up a nominating commission to review anybody that wants to apply, just like was in existence before the legislation was changed, to do away with the nominating commission for the Court of Appeals. Governor Brownback did not do that. He just selected who he wanted, and then the Supreme or the Senate would confirm or not. So there's no guarantee of what any governor will do, but Kelly has always elected to have a nominating system process so that anybody could apply and the applicants were public.
Okay, cool. There's one more in here. I think this is really interesting. If yes wins, can the amendment be challenged in Kansas courts on a constitutional basis? That's some nitty gritty, isn't it?
I don't know that it could be. I mean, people can decide, just as they passed an amendment saying we have the merit selection system.
And courts don't just get to pluck an issue out
Right.
of the universe and decide it. It would have to be the result of someone bringing a cause of action that makes its way up to the Supreme Court, that is, the Supreme Court is asked to rule on, so.
Now that I've said that, I'd have to recuse if it ever came to me, but I don't know that, I mean, I can't think of why that would be unconstitutional, that people vote that way.
Okay. This patron is disappointed tonight in the presentation, and said, I came in good faith to hear both sides of this issue. Clearly, this is an attempt to persuade voters to vote no, presented by those who are deeply embedded in the current process, which they of course favor. So we're advocates to vote for the yes vote. And how do you feel about that? I mean.
Yeah, we included literally quotes on the slides that advance that side. And as you know, people with free will, we're free to reject it or accept it or like it or not. And I don't take it personally at all.
Okay. Yeah. And at the library, we like to show both sides of every issue. We believe everybody has a right to every bit of information. And but thank you for the suggestion. Maybe sometime we'll have more of a panel discussion.
And I do want to just say one more thing. I take exception with the word embedded in the system. This is a system that I chose to participate in because I just so passionately love our system of government. I love our system of checks and balances and having 3 branches, and I love our legal system. And I feel very passionately that maintaining fair and impartial courts is best for our community. So I'm not at all, reluctant to say that or to be proud of that. So,
okay, thank you. With the current Kansas Supreme Court justices, have they ruled more conservatively or liberally? How can we check on the rulings? And I think you talked about some places to look for that in the presentation, but maybe say it again, because I've had that problem before, looking for judges' records.
All I can tell you is what's on the literature that I've seen passed out on both sides. And the literature for the vote no group has pointed out that the Kansas Supreme Court has ruled against Democrat governors and Republican governors equally. They've ruled against Governor Kelly, they've ruled against Governor Brownback. They don't seem to be picking and choosing sides. And controversial cases are hard. I mean, they're gonna come up, and the ones you're gonna hear about are, the ones just steeped in controversy. But the reality is, with the United States Supreme Court and the Kansas Supreme Court, most of the cases are unanimous decisions, 9-0, or 9-0 with the United States, 7-0 with Kansas, but these issues like abortion and school financing, whether you can say that's a conservative decision or a liberal decision, it's a decision based on their interpretation of the law, and if you think they got it wrong, change the law. I mean, that's what our whole system is about, so.
Okay, great, thank you. There are a few more, if everybody can hang on. As a retired attorney who did a lot of jury trials, and personally know some Kansas appellate judges who I believe never tried a case as an attorney, why should I respect the process by which they were selected?
does it say Court of Appeals judges?
It says Kansas appellate judges.
Well,
That's different.
Court of Appeals judges are not on the ballot right now, and the process for them being selected isn't on the ballot. I'm looking through the lens of the applicants we've vetted and are largely, and most of our applicants were trial attorneys and then district court judges. So
The appellate judges,
colleagues that were not trial attorneys.
but anyway, the appellate judges, didn't you say they're the ones who are nominated by the
Governor, right.
and then confirmed by the Senate, and so they don't really have the same.
Now, whoever asked that question, if you want to come up to me later, I'm trying to think who hasn't had litigation experience on my court, and I think I don't know.
Okay,
Have to be
well, maybe afterwards you can have that conversation, that's okay. Got a couple more. Under the yes scenario, it is not clear how judges are selected before they run for their election. Can you clarify? So do they just raise money and run like any?
Yeah.
Yes.
Direct elections, so just like a legislature or any statewide office.
And there's no like, educational requirement?
We
or-
don't, no.
Okay.
I mean, they have to be lawyers.
And that's the rule now, but there's nothing
We
to
don't
say
know.
they can't change
Yeah,
it.
we don't know, we don't have that information.
Okay, we have two more, it looks like. I am just a citizen. Why would I vote to have elected judges? I think this maybe means just as an average person, a person who's not an attorney. I hope I got that right. I can't remember who gave it to me. But why would, can you explain why someone would want to vote?
I think people want to have their voices heard, and I think for people who want to be engaged and involved in their democracy, the idea of that, I think that's what you said the sexy argument was. You know, there is something appealing on first glance about that, so I
And
think
if
that,
you feel judges should rule consistent with public opinion, then vote yes.
Okay, and here's the last one. Why are 6 of the 7 current Supreme Court justices Democrats? Well, first is that.
I don't know that they are, I need more information, Max Foundation, I don't know.
Okay.
I'm looking, I'm going through my notes.
I think what maybe, there might be a distinction too, we've had a 2-term governor who has had several
Yeah,
appointments,
she said
so
right.
I don't, maybe that's what they're looking at, current justices who were appointed by a Democratic governor.
But you know, the
That's
tides
just the nature.
change. When-
Right.
Just like right now, I think all the non-lawyer members were appointed by Governor Kelly.
Right, because they're 4-year terms.
But that'll change. I mean, it just goes with the flow.
There was a time where the same would be true for a Republican governor who had appointed most of the justices and most of the nominating commission, so.
Well, those were all of our questions, and thank you. We went longer than we thought we were going to, but I learned so much tonight. Thank you so much for explaining how this works. I live in Missouri, but it's the same system, and so I'm really happy to learn. So thank you very much, and thank you for all your civility and kindness.
Katie, were you appointed during Kelly's term to the committee?
At the very, my very first was like 2020, so yeah.
20, was that before or after you donated to her?
After.
After. And have you donated to any Republicans or any other parties, I should say?
Lots.
Okay, that's good to know. What can you name one of them?
John Scooble, Jan Kesterman. Those are the 2 that come to mind because they're my local guys.
Okay. Well, thank you so much.
Well, that's my first. Thank you. Thanks for mostly divorce. Probably, yeah. And prenups and things.
They're popular, huh?
Are you just the videographer?
Oh, I practice, yeah, full time.
I record all sorts of interviews for public office. They call them forums and debates. And this is kind of like that. It's an interview for the outcome of the yes/no.
So that's what they're talking about, where you can see all these things online.
I would be so honored if they were talking about me, but they don't usually acknowledge me because I don't agree with them all the time. So, if you just search it on YouTube, you'll find what I post. Search for like, the yes/no debate at JCL. It'll be up by tonight. So, the library has an official videographer in the back.
I will get it to the library and they can.
You'll get it. Thank you. Yeah. If you register, yeah, if you register, if not, I'll just make a list. Okay. If you're registered, I'll auto send it to you. Okay, that's what I thought. If you're not registered, then I'll take it out of your. We can try. Understood, yeah.
Thank you.
Well, that was the Vote No Promotion campaign put on by the Johnson County Library. See you around Johnson County.